Hello and welcome to our webinar, New HR Laws in the New Year, How to Prepare in 2016. My name is Julie Dorr and I will be your moderator for today's event. Our presentation will last approximately 40 minutes with the remaining time available for your questions. If during the webinar you have any questions, feel free to type them in the designated questions section. You'll find that on your dashboard. Or if you're more comfortable, email me at julie@thedoorgroup.com, and that email address is right on the screen. And of course, if you are wondering where the heck your presentation is, it's actually in Linda, I think you're starting the webinar or something here.
I don't know what it is.
Okay. Okay, I'm sorry, guys. We'll back up just a second. In case you're wondering where your handout is, it's in the dashboard that is actually also typically on the right-hand side of your screen. And you can go ahead and go in there and download the handout. And again, if you feel more comfortable, email me, and that I can take care of for you right away. Also, wanted to let you know that this webinar and all the accompanying materials are protected by copyright, and that the entire conference is being recorded. This presentation provides general information only, and should you need legal advice, please contact your legal counsel and address your specific situation with them. And Linda is definitely anxious to get going today, but it's always my pleasure
get it to work, like usual.
to introduce our expert panel. First, again, it's Linda Duffy. She's the president of Ethos Human Capital Solutions. Linda is a trusted HR advisor and works with business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. And then, of course, we have her partner in crime, attorney Marla Merhab Robinson. Marla has extensive business experience, and it's with the law firm Merhab Robinson, Jackson, and Clarkson, where she's a partner and head of the firm's transactional department. She primarily practices in the area of corporate, mergers and acquisitions, real estate, finance, and employment law. So we are going to go ahead and give this over to Linda so that she can actually manage and work the slides while she's talking to us about the agenda. And Linda, can you let me know how you're doing with those slide navigations?
Yeah, we will. Time will tell, right? We will see. It's always something with us. Anyway, thanks so much, Julie, and welcome everybody. We're so happy to have you with us today, and we're excited to get started on our first webinar of the year. In a little bit, we'll also share with you the next date we have, because we're going to be touching on leaves of absence, and that's going to be our topic in February as well. So I'm not going to spend a lot of time on the agenda. You can all read it for yourselves, but we will jump right in and start talking about minimum wage. So the good news is there wasn't a ton of new laws that came out this year, but there were some that were pretty significant. So we want to make sure that we spend some time on that. And then, as always, we'll save room for questions at the end. So most everybody knows, I'm sure, that minimum wage went up to $10 per hour effective January 1st. So you want to make sure that you don't have anybody still at $9 an hour or anything below 10. Certain counties throughout the state are higher, like San Francisco, for example. And there are others that are planning to index that. Like I know Los Angeles is planning to index that to get people up to $15 an hour, but that doesn't go into effect. It's a step up to, I think, 2020 when they finally get there. A couple of things that are significant you want to watch for: wage compression. And what I mean by that is if you had people that were at $9 an hour, let's say, and you have people at $9.50, and you had people at $10 and $10.50, now everybody, you know, is smack dab up against each other at $10 an hour. So you want to just take a look at that and see if you need to make adjustments to other people in addition to just bumping everybody up to $10, because now the people that were already at 10 are going to have all of their people next to them that were at $9 and $9.50, and there was a reason you were paying them more to begin with. So you might want to take a look if you need to make other adjustments. Just a reminder, you have to provide the written notice of change within 7 days using that wage theft notice. It can be on the wage statement, but I will say, and maybe Marla can jump in on this later, you know, it says that you have to reissue that every time there's a change in anything there, but the one exception was if the only change is a wage change and it shows up on the wage statement, then you're fine. The problem is rarely does the overtime and double time rate show up on a wage statement unless somebody actually has taken it. So maybe we get Marla's opinion on that later. But if you have made changes and you haven't issued that wage theft notice, you want to make sure you go back and do that. The other thing that's really critical is that this impacts the minimum salary requirement for your exempt employees. So in California, that's twice minimum wage, and so if you have employees that you're paying a flat salary to that are making less than $41,600, that means you need to either convert them over to an hourly status or you need to raise them up to at least that 41,600 number. And again, that's higher for computer professionals, of course. Just on a side note, this is always a good time to review your exempt classification. So if you need help with that, by all means, reach out to me or Marla, because that's one of the biggest issues where we see problems all the time when I go into audit companies, and I'm sure Marla would agree with this, people misclassifying people as exempt. So just think about that and let us know if you need some help with that. Okay, piece rate and non-productive hours. This is honestly one of the craziest things that the legislature has done in a long time, in my opinion, that at least affects employees in California. So this is an updated slide, but a slide that I took out of our payroll webinar a while back, and we were talking about piece rate, and it used to be because the federal law says if you just take all money that somebody earns during the week, divide by the number of hours they worked, and as long as it's over minimum wage, you're good to go. Okay, so let's take, it says technician. Let's say this technician's like a car technician, for lack of a better word or phrase. Somebody, they're going to get paid, $50 for every carburetor they fix, something like that. Let's say the technician works 35 hours out of 40. Well, if they made $500, they did 10 carburetors that week. The incorrect column is sort of the federal law. It says take the 500, divide by the number of hours worked, and as long as it's over $10 an hour, you're good. Okay, in 2013, there was a case, Gonzalez versus Downtown LA Motors, and the court said, nope, you've got to pay them for any non-productive time because that time is still under the control of the employer. So I do a carburetor, I'm sitting around waiting for my next assignment, my next carburetor, I'm sitting around not technically producing anything in that moment, but I'm subject to the control of my employer. So California said, nope, what you got to do is you've got to pay for that, what they call non-productive time. So in my example, I work 35 hours. The other 5 hours I'm sitting around waiting, that's non-productive time. I have to be paid at least minimum wage for that. So correct last year until December 31st, you would just say, okay, as long as I paid them the piece rate plus any non-productive time, then I'm good to go. Guess what? Now California says, nope, not good enough. Now, in addition to paying for non-productive time, you have to specifically pay for rest and recovery time. So essentially breaks. So this is the new standard. And I'm going to go through some of the other requirements in a second, but let's just go through some simple math or not so simple math so you can understand. And honestly, I spent a great deal of time over the last few days with one of Marla's associates going back and forth about how to calculate this. It's just math, right? But it's a little bit complicated to understand. So if you don't get this, reach out and one of us will help you with it. But essentially, I work 35 hours out of 40 and I earn $500. That's the same as last year, right? Now I take a look at those other 5 hours that were my non-productive time, and I say, okay, well, if I had 2 10-minute breaks a day, that's essentially 20 minutes a day times 5 during the week, so 100 minutes or 1.67 hours. And then the rest of that is my non-productive time at 3.33 hours. The non-productive time has to be paid just at no less than minimum wage. So you can pay that at $10 an hour, as I gave you the example here. The rest and recovery time, however, has a completely different calculation, and it has to be paid at the higher of minimum wage or the average hourly wage exclusive of break time during the week. That is the calculation at the bottom there. So you take the total work week compensation, you don't include the rest and recovery compensation or OT premium, and you divide it by the total hours worked, not including the rest and recovery periods. So in this case, we're going to add the 500 and the 3330, and then we're going to divide that by 38.33 hours, which is the 40 hours less the break time, okay? So hopefully your head hasn't already exploded on this, because it gets just a little bit worse. The math there is done, but now you have other requirements in that you have to also show it on the pay stubs. So you have to compensate employees. This is effective January 1st. You have to compensate employees for rest and recovery periods using the formula I just showed you. You have to compensate employees for other non-productive time at no less than minimum wage, and you have to break all of that out on pay stubs. So you have to show the total hours of rest and recovery periods, the total hours of non-productive time, the rate of compensation for each, and the gross wages for each. Good luck getting your payroll companies to do that. I have no idea if anybody is set up to do that at all. Now, this sort of good news, if you want some good news, is there's some limitations to this, and I'm going to just direct all of you to Marla right now for this. If you are paying piece rate to your employees and you look at these slides and you go, wow, Linda, we weren't doing that the last few years. We weren't paying for that non-productive time. There is a safe harbor for employers who want to correct compliance issues. It's limited under certain circumstances, and there is a time deadline on that. But what I would suggest you do is reach out to Marla right away so her firm can help you become compliant with that and get you back in the good graces. Overall, Marla and I have talked about this extensively. Our recommendation is figure out a different way to compensate people than piece rate, because this law is going to impact a lot of companies. It's going to be very difficult, in my opinion, to be compliant with this, and you're going to be doing a lot of manual calculations. Okay, let's move on and talk about sick leave. Everyone knows the sick leave law went into effect a year ago, and then in July 1st, everybody needed to start offering sick pay. Hopefully, everybody's up to speed on that. The only reason I'm including a couple of slides on this is because the law was amended on July 13th. Our last seminar was in the month of June to help everyone be prepared for that. So I just wanted to go over a couple of things that actually I think were to the employer's advantage. So if you look at the changes that were made, eligibility now requires 30 more days working for an employer with the same employer within California. So before it wasn't clear on that, you could potentially work for multiple employers to hit that 30-day mark. Now the eligibility it says it's the same employer. There are alternative methods of accrual, which is great, as long as the employee is going to have 24 hours of sick leave available by the 120th calendar day, even though they can start using it on the 90th. You have no obligation to inquire into or document the reasons that sick leave is used. So if someone comes to you and says, I need sick leave, have them fill out the form to say I want to get paid sick leave, and then that's it. You don't have to ask any questions. And there are also, and that was one of the big ones, alternative methods for calculating the payment. So you might recall before the requirement was you had to do this crazy 90-day look back. Now you do not have to do that. You do, however, have to pay it at the regular rate of pay, which is a completely different calculation. That's not the same as base rate. So that's an area we see a lot of mistakes made, not just on that, but on overtime calculations as well. Both of those have to be paid at the regular rate of pay, so it takes in other payment besides just the base hourly rate. A couple of things, if the employment's rehired within a year and you don't pay out their sick pay because there's no requirement to do so, it has to be reinstated. But if you have a PTO policy, which a lot of my clients do, and they're paying out the PTO upon termination, and then subsequently if they rehired somebody within the year, they do not have to reinstate it because it's already been paid out. So that was a good clarification as well. And then finally, I do have one or two clients that are using unlimited vacation or sick pay for some exempt level employees, and now because we have the requirement to show the available sick pay on the pay stub, you can just satisfy that requirement by saying unlimited. You don't have to come up with some other way of saying how much time is available. Okay, so hopefully everybody's in compliant with sick leave, but again, we can help you with that if you need any sort of guidance. Everybody's probably heard of the Private Attorneys General Act. It's been around, I don't know, about 10 years or so, PAGA for short. This is actually one of the good news of the year is Governor Brown signed a bill that provides a little bit of relief to employers in that there are so many things now, and this is going to come in handy with regard to the piece rate requirements as it amends PAGA to give employers, I think it's 30 days, but it's a limited right to sort of fix any sort of deficiencies with wage statement violations. So if you're not showing everything you should, if your pay period dates are off, if you don't have the correct legal address and name of the employer on the pay stubs before an attorney could come and just bring a civil suit, and now I think it's 30 days that you have to correct any sort of deficiencies. You can only do it once during a 12-month period, but at least you can't get sued right away for it, so that's some good news. Okay, whistleblower protections. Assembly Bill 1509 did a couple things. It expanded the whistleblower and anti-retaliation provisions or protections to family members of whistleblowers. So you can't retaliate if somebody else in that person's family is a whistleblower. You can't take action against the employee. And it also expands joint employer liability, and this is going to show up a lot going forward. So this is not good news for temp agencies and potentially not good news for employers if you're using temp agencies because there's joint employer liability there. So you need to make sure that both parties in that relationship are going to be compliant with all laws. It amends 4 different sections of the Labor Code. I'm not going to bother reading those off, but there's 4 different sections that got amended by this particular bill. So I mentioned we're going to be doing the next webinar on leaves of absence. Our next 2 webinars are going to be on leaves of absence. And for those of you that have downloaded the handout that you see over on your dashboard to the right, I think it's probably the very last slide. You'll see the date of the next one. We're going to focus the next leave on medical leave of absence, so FMLA, CFRA, pregnancy, probably workers' comp, and then the following month we're going to do all the rest of the leaves because in California there's like 20 of them. So this particular Senate Bill 579 expanded a couple of different things. So already there's Labor Code 230.7, which allows parents and guardians of school-age kids to take school visitation leave so they can go to disciplinary hearings. So if your kid's about to be expelled or suspended from school, you can take time off to go, and that applies to employers of all sizes. There's also Labor Code Section 230.8 that requires employers with 25 or more employees in one location to provide up to 40 hours per year of time to attend or participate in activities at school, so like soccer games or school plays or something like that. So what this leave did is it expanded a couple different definitions that impact those 2 Labor Code sections. So one is that it now covers time off to find a school or a licensed child care provider or to enroll or re-enroll a kid. So now you can take time off for that. You can take time off to address child care provider or school emergencies, and it also expanded the definition of parent to include step parent or foster parent. And then finally, all of the references in the law used to say child daycare facility, and now they are changing that definition or reference to child care provider. So it doesn't have to be a child daycare facility specifically. Okay, disability insurance. Right now, if an employee has any sort of medical disability, they go down to EDD or online to EDD and they apply for state disability insurance. There's a 7-day waiting period. Well, right now, if that person suffers a relapse within the 14 days, so let's say they go out on their medical leave, they come back to work for a week, and then a week later they go out on the medical leave again. Right now, if they're in 14 days when they have that relapse, they sort of waive that waiting period again. What this law is doing is extending that 14 days to 60 days. So if somebody goes out on disability, they come back to work, they go out again, they don't have to resatisfy the disability benefit period, as it's called, as long as it's within that 60 days. This is, I think, the only law on our list. I could be wrong, but I think this is the only law that's not in effect yet. This will go into effect July 1st of this year. Okay, and the last slide I'm going to talk about before turning it over to Marla is E-Verify. So Assembly Bill 622, basically all it's doing is stating the same thing that's already true at the federal level, which is you cannot use E-Verify to put employees through to check on them until you have offered them employment. Okay, so until, I should say, offered and they've accepted employment. So you cannot just go out and say, I want to check all, check all of these candidates or anything like that. You have to actually make them an offer. This is already true of federal law, so when you log into E-Verify, there is a memorandum of understanding that you agree to when you enroll in E-Verify. So really this is not changing anything, it's just making it California law in addition to federal law. And with that, I am going to turn it over to Marla.
Thank you very much, Linda. And as Linda said, there are not a lot of changes this year, especially not a lot that are going to require handbook changes and things of that nature, but there are some significant ones. And the next one is SB 588, which you may have read about or heard about online about changes for the labor commissioner. It gives the labor commissioner authority to file a lien on real estate. Of course, this is after the failure to satisfy judgment after notice to the employer. It also gives the labor commissioner authority to levy on an employer's property or to impose a stop order on the employer's business as a means to remedy non-payment of wages. These are significant remedies for the employee enforced by the labor commissioner. Before, we had the labor commissioner had the ability to go after bank accounts, garnish bank accounts. Of course, you could appeal only if you have the bond. Here again, you can put a bond up to $150,000 if you don't, or be required to put a bond up for $150,000 if you don't properly pay a judgment. Currently, you have to pay a bond if you're going to, as an employer, appeal. But the most significant change here that has kind of, in my opinion, not received the press, the notoriety, the internet disclosure that it should, because it's significant, and that is that it allows for personal liability for individuals who violate certain labor code provisions while acting on behalf of the employers. And that portion of 588 is actually found in Labor Code 558.1a, and it creates personal liability not just for the non-payment of wages, but for other things such as the failure to provide the pay stat.
Marla, I hate to interrupt you, but we're getting some feedback from some of our listeners that they can't hear you very well. Could you move the speaker maybe a little bit closer to your mouth?
Is this better?
That's much better. Thank you so much.
Okay, I apologize.
Sorry,
I didn't realize that it was on speaker, and I apologize for that. I didn't realize it. So let me just reiterate for those who didn't hear. This is SB 588 that makes some changes to how the labor commissioner can go after employers to seek judgment on behalf of the employee, and its remedies such as liening real estate after attempting to collect judgment after notice, or going after other employer property, where before we only had, the labor commissioner had the right to go after bank accounts, levy on bank accounts. That's significant, but it's not what I believe is the most significant change here in this law, and what I believe is not getting the recognition as how horrible it truly is, and that's the personal liability that was created by this law that can actually, it can be found in Labor Code 558.1a, and it's not just for non-payment of wages. Currently, before this change, we've had many cases come down, one in fact that my office worked on at the appellate level, but even at the Supreme Court level, that said, no, we don't have personal liability for non-payment of wages in California. We don't have that. Well, this legislation changes that, and not just for non-payment of wages, as I said, in Labor Code 558.1a, also for other things such as failure to provide vouchers or pay stubs. That personal liability extends to officers, directors, owners, and managing agents. And managing agent is kind of a unique term, but it would certainly be somebody who the principal is given authority to do certain things. This is huge. Everybody should be looking at their wage and hour laws to make sure there's compliance so that there's no personal liability, because there wasn't any before. And because there wasn't before, and because this hasn't gotten a lot of publicity, I think there's a false sense of security out there with a lot of employers. And I know that my office, at least, we will be taking some time to try and get the word out and educate employers, both clients and otherwise. It also, this also allowed a commissioner to, if we go to the next slide, to investigate and enforce local overtime and minimum wage laws. Now, the labor commissioner has always been authorized to investigate and enforce minimum wage laws, but now it's also the local overtime laws, which, as Linda pointed out, can change depending on where you are, LA, San Francisco, and the labor commissioner can issue citations and penalties where the employers have failed to reimburse employees for employer-required expenses. This is significant because to me, because it's been coming up quite a bit with the employers we talk to about what are expenses that you have to reimburse. And the labor code is so general, and this is not a change, this is current law, that any expense incurred by the employee that is for the benefit of the employer must be reimbursed. So we did, I don't know if everyone remembers, but last year or the year before, we had the change in the law regarding the cell phone usage, and you had to make some determination of, even if they were using their own phone, if they were using it sometimes for the employer's business, what percentage of that was for the employer's business, and let's reimburse for that. Well, now the question is coming up about home computers. If you're using your home computer for your employer's benefit, should a portion of that be expensed, and should you pay that? So I encourage you to talk to counsel or someone like Linda about that and get some answers. So the next change was to the California Fair Pay Act. Linda and I were laughing when we were preparing. It's also received some other names, but it's SB 358 and amends Labor Code Section 1197.5. As an attorney, I never pay attention to the names given that are not the code sections. We always look at the code sections. But the existing law prohibited an employer from paying an employee less than rates paid to the opposite sex if the employees were in the same establishment and they were performing equal work on jobs requiring equal skill, effort, and responsibility, and were performed under similar working conditions. The new law removes the requirement of in the same establishment and prohibits an employer from paying an employee less than rates to be paid the opposite sex for substantially similar work when viewed as a composite of skill, effort, and responsibility as specified. But that's not the only change. There are exceptions to this, and the exceptions are seniority, merit, quantity or quality of work or production, or a bona fide factor other than sex. The new law revises the bona fide factor other than sex. Those exceptions were in the old law, but the new law revises that, the one factor. And that change requires the employer prove a wage differential is not based on a derived form of sex-based differential and is consistent with business necessity. An example of business necessity would be education, training, or experience that is job-related. It means, from a legal definition, it means an overriding legitimate business purpose such that the factors relied upon effectively serve the business interests. The employer has the burden of proof and must establish that each factor is applied reasonably and that the factors relied on account for the entire wage difference. And that's the only reason for the wage difference are these factors. This SB 358 also amended the requirement regarding retaining records from 2 to 3 years, and it added a prohibition on discrimination, discharge, retaliation, and the right to invoke those, of course. It changed the statute of limitations on that from 1 year, or excuse me, it lifted the statute of limitations on that for 1 year, but also gave the commissioner the right to do that. Your takeaway here with respect to this change is to be sure to review all your pay with respect to people who are performing the same job, and if there's a differential, find out why. The law does not specify geography as being a factor that can be determined. However, many attorneys argue that that can be part of the business necessity. So if it falls in there and the attorney can make that argument, then that would be one of the exceptions. The record keeping requirement change from 2 to 3 years applies to wages and wage rates, job classifications, other terms and conditions of employment regarding the same and similarly situated individuals. Governor Brown referred to the new law as the strongest equal pay law in the nation. So it's another one of those things where California is going to lead the nation in employee protections. I'm on the slide for the pay secrecy. Thank you. The pay secrecy prohibited. This is already prohibited under the National Labor Relations Act, but it is set forth here again and allows employees to disclose, discuss, and inquire about their own and others' wages, and to aid other employees in exercising their rights under this act. And there's a private right of action, again, as I said before, as well as the labor commissioner can bring. That's significant for those who ask, well, what difference does it make that I can bring the action myself or the labor commissioner can bring? If the employee does not want to have to engage an attorney, they can go to the labor commissioner and ask the labor commissioner to bring on their behalf. And that's significant because it makes it easy. There's no loss to the employee for the payment of a contingency payment to an attorney. The labor commissioner at the DLSC would administer and enforce through penalized back wages and interest, and again, the employee can file their own. On to AB 987, which is another discrimination, anti-retaliation protection for employees. Employers have always been prohibited from discriminating or retaliating against employees who were in a protected class and received an accommodation for disability, religion, or other protected class. This act or this statute expands the protection to the employee for the mere act of making the request, just asking for an accommodation, even if the accommodation isn't given. So, for example, if you have an employee who comes in and says, I need to take Thursday off, and the HR director says, well, why do you need to take Thursday off? And the employee says, well, it's my purple hair day. Every Thursday on the 4th moon rising of Aquarius, I get my hair colored purple. Was that tied to religion? No, the employee says it's not. It's just my personal thing. I like to have purple hair on the 4th day of Aquarius rising. And the HR director says, no, I'm sorry, you can't have that. Well, this law prohibits the employer from taking any action, terminating, retaliating, or otherwise discriminating against that employee for the mere act of requesting. So that the request itself is a protected activity. You do not have to be in a protected class, which is a little bit unusual compared to many of our other laws in this area where you do have to be in the protected class to get the protection. Here, you get the protection merely by making the request. This is not great for employers, and their takeaway here should be we really need to do some training with our supervisors and HR directors to make sure that they know this. So we did have some good news in the area of cases for employers, and that would be the DirecTV versus Imburgia, and I don't know if I'm pronouncing that correctly or not, case that was decided just last month, December 14th, 2015, and it's the U.S. Supreme Court. So that's the highest court in the land, as everybody knows. So that you would think that would be the end of it, but they seem to have to keep coming back to the California courts and telling them, you're not listening to us when it comes to arbitration. We favor arbitration. In this case, it was DirecTV and its customers had entered into service agreements that included binding arbitration provisions with class action waivers. The entire provision, the agreement said that the arbitration provision was unenforceable if the law in your state didn't allow class action waivers, and at the time California didn't. So when the court looked at this, they said, nope, California's class action waivers are unenforceable, so the entire arbitration provision won't be unenforceable because they were, in fact, allowed. This is fantastic news for employers. Again, if you have a properly written employment agreement that has an arbitration provision, which you should, it is one of the few types of agreements that in my firm we highly recommend arbitration provisions. You can also have a class action waiver provision so that you're not going to get hit with that class action wage and hour suit, and you're not going to get hit with that class action discrimination suit if it's properly written. There are a lot of rules in California law with respect to what has to be found in an arbitration provision in order for the arbitration provision to be enforceable. But if those rules are followed, then it's enforceable, and then now we have the Supreme Court saying, and if you include in an enforceable arbitration provision a class action waiver, that will be enforced too. Very, very good news for employers because the class action lawsuits are the most onerous and the most expensive and can take an employer out of business. The next case of note from last year is the Prue versus Brady case. And in this case, this was an employee who suffered a work-related injury, so a workers' compensation injury, and then filed a lawsuit against the employer for wrongful termination in violation of public policy. Now, those of you who have had workers' compensation claimants before who were terminated or even thought they were terminated, because this happens quite often, they think they've been terminated when in fact they haven't. They file what's called a 132A action that's named after Labor Code 132A, which states that an employer cannot retaliate, discriminate, terminate, or take any action against an employee because they filed a workers' comp claim or participated in a workers' comp claim. The reason you see that most often is because it's a very simple, inexpensive way for the employee, and usually the employee has a workers' comp attorney, to file that wrongful termination claim. It's a petition. Sometimes it's 1 or 2 pages. It's filed in the workers' comp court, which is a very inexpensive filing, and so it's heard there, and oftentimes it gets lumped in with settlement discussions on the workers' compensation claim. This employee chose another route, and that was to file in state court for wrongful termination in violation of public policy. And the employer argued, no, you can't do that. This is a Labor 132A action, and you can only go in front of the Workers' Compensation Appeals Board. We've been telling clients for years that's not the case. They're just lucky that it's so inexpensive and fast that that's where most employees go. And this court confirmed that and said, no, the employee has the right under a 2-year statute of limitations to bring that action in state court in violation of public policy under FEHA, and is not barred by the workers' compensation exclusivity rules and not required to bring it solely in the workers' comp area. And with that, I will turn it over for questions. Hello?
I don't know. Maybe we lost Julie.
My apologies. I actually hit the wrong button and ended up getting disconnected. So it's our first one after a few months here, and I'm a little rusty, I guess, at my webinars. But you and
me both, Julie.
We got speakerphones going and all sorts of stuff. But still great content. Thank you so much, ladies, for helping us get up to date on 2016. That does conclude the presentation portion of our webinar, but we've got about 20 minutes or so here where we can answer questions, and I know some of you have already been entering some of those. So just very quickly, just go to your question tab on your dashboard section, type in your question, hit send, and we'll be able to read that aloud for both Marla and Linda to answer. So let's start here real quickly. Linda and Marla, here's one here about exemption salary from Diana. She thought the exemption salary was $50,440. Is that correct, or is that not correct any longer?
I don't know where that number's coming from. It's twice minimum wage.
Oh, it's twice minimum wage. Okay.
Yep. So
okay.
$10 an hour times 2 times 2,080 hours is going to get you $41,600. So you got to remember, federal law is always different from California law. So you always got to take the higher standard. But in this case, California law is pretty clear. Twice minimum wage.
Okay, good. Thank you. And Diana, if you have another question, just type in the question area. Doris has a question. How does the exemption minimum salary requirement in California interact with the FLSA exemption minimum salary requirement?
I think Linda just answered that.
Okay.
Yeah.
Got that.
I mean,
you have to know.
I mean, there's a few differences. I mean, there's a few differences between the federal law and the state law. There's a lot of similarities as well, but you always want to make sure that you're taking a look at California law, because undoubtedly the standard is going to be higher in California. So, like, another difference between the two is, and Marla can explain this probably better than I can, but federal law says what's the most important duty this person has, and if that's exempt, then you're fine. You can have that person be exempt from overtime. California says no, you got to take a look at where they're spending, the majority of their time. So this comes up a lot for the management for the executive exemption, where you say, oh yeah, they've got 2 employees that report to them, they're 2 full-time employees, so check, they're exempt. And I'm like, nope. Are you telling me that this person is actually spending more than 50% of their time, you know, hiring, firing, training, managing those 2 employees? No, they're working alongside. They just happen to be the manager. That's not an exempt function. And so you've got to be really careful and sort of look at the fine print on that, because we see misclassification all the time. And this is a big one if people are working overtime, as most exempt people, you know, are known to do. And it can go back for years that you end up paying overtime for people. So you want to definitely make sure you have them classified correctly.
Okay. And Marla, did you want to add anything?
Yeah, I was just going to add, ditto what Linda said. And yes, California very often it is different than federal, and you have to look, and whichever is more beneficial to the employee. If you're not sure which one, just say which one helps the employee out the most. That's what counts. And you know, here in California, the hometown corporate headquarters of Taco Bell, they were one of the biggest awards against them for exempt versus non-exempt, because they had what were called key managers who did have authority to hire, fire, promote, demote, and set schedules, but you have to do that 51% or more of the time in California, and they were selling tacos 51% or more, and the management duties were less.
Okay, good, thank you. Doris has a question about whether or not you guys would recommend that we revise our company whistleblower policy to include AB 1509 changes.
Marla? I mean, I don't know what the current policy would say, so without knowing that, I mean, hopefully nobody's going to retaliate against a company or against an employee for any reason, right? Especially not because a family member is a whistleblower. So if that's what you're referencing, I don't know that you need to really update the handbook at all or your policy about that. If this is important for your industry, though, take a look at that, because I can imagine certain industries would need a more specific and more restrictive policy. But definitely you want to train your managers what they can and cannot do on a few of these.
Sorry, Linda. I'm sorry. I thought you were done. So same comment as Linda. I would never recommend to anyone revising a policy without seeing what the current policy says, because it may already be covered, and we definitely don't want to take the time, the money, the effort, and confusion of the employees. But Linda had the slide and I didn't, but just for everyone's benefit, the reason this law was adopted was to protect those family members that actually work in the same place of employment as the employed. There was a lot of that that brought about this law. That doesn't mean that they have to. That's just the reason for it. And so if your policy already kind of protects that and you not really have any other issues, it might be enough. But again, just like Linda, I would want to look at whatever the existing policy says before recommending a change.
Okay, great, thank you. Peter's wondering, can we front load 24 hours of PTO and start accruing PTO after 9 months and still remain compliant with the sick pay laws?
That is such a great question, Peter, and I actually did confirm with Marla last night after you and I talked. So yes, so what Peter's talking about is they have a situation where they want to provide six days during the first year of PTO, right? Call it sick, PTO, whatever, and then it'll go up to two or 12 days actually, year 2. So we were brainstorming ways to do this, and if you just look at the normal accrual, the employee, if you're doing the accrual for 6 days over the course of a year, they would not have their 24 hours by the 120th day, because it would take them 6 months to accrue it. So that would not be compliant with the sick pay law. So we said, so you have to front load it if you want to do it that way. But we started thinking about it, and what I'm going to recommend, Peter, is that you front load the 24 hours as sick pay, so therefore it does not have to be paid out upon termination. And because California does not require that you actually even give vacation time, then what you can do is after 9 months start accruing at the higher rate we talked about, start accruing PTO. So essentially employees are only going to have quote-unquote sick pay for that first year. Then it'll go away. They'll start getting the accrual after 9 months, and then you're good going forward just calling it PTO.
Okay, great. Marla, did you want to add anything?
Just that I agree, with the understanding that the sick, because we just talked about it last night, we really did. But understand that the sick leave law is brand new, just went into effect last year and just got amended again a couple of weeks after. Well, actually went into effect in January. You had to comply by July, then it was amended in July. So we're going to see changes, but right now the way the law is written, it's very clear from a legal argument that you don't even have to call it TTO. It's just a policy that, yes, you can go ahead and do that.
Okay, great. Catherine has a question on whether these laws apply to all employers, or is there a minimum head count, like under 50, that, where these laws are applicable?
The ones we went over today, everybody.
Everybody with, there was one exception I mentioned on the school one.
Yeah.
That it only applies to 20 if you have 25 employees or more in the same location. Other than that, I think everything we talked about applies to all employers.
Okay, great. We've got several questions on the California Fair Pay Act, and one person's asking if you could just summarize it for us, and another person's asking whether or not you could cover the liability, because if there's calculations and they're submitted to payroll, or you use an external payroll firm, who's liable? How do you check those errors? So could you maybe start at a higher level, talk about the California Fair Pay Act, and then maybe talk a little bit about liability?
Yeah, it has nothing to do with payroll. The Act is about paying people who are doing the same job, the same pay, and not paying them differently based on their sex. I would expect, but just the way these laws go, that definition of sex is going to be expanded and added to as well. But you can only pay people of the opposite sex differently for those reasons I gave you, those exceptions: seniority, merit, quantity or quality of production, and bona fide factor other than sex. And that bona fide factor, if that burden of proof is on the employer to show that whatever that factor is, it's not based on sex at all, and it's consistent with a business necessity. And a business necessity has to be a legitimate business purpose. It does not specifically, as I said, identify geography, but we believe that would apply. So, for example, if you had somebody who was working in New York, you would pay them more because it costs more to live in New York than you would if they were living in Kansas, because it doesn't cost as much to live in Kansas. That type of thing. The $50,000 view of the law is you cannot pay people of the opposite sex different pay for equal work.
So let me jump in on this one, because here's where there's going to be a lot of problems, okay? From a practical standpoint, someone applies for a job, right? How often do you actually sit down, unless you have a very formal pay structure, and most of my clients do not, how often do you actually sit down and say, well, let's take a look at what we're paying everybody else, as opposed to what was this person making in their last job? And that's how a lot of times those offers get made. Well, the person was making $15 an hour, and they say they want $16 an hour, so that's what you offer them because you want to hire this person because you think they're going to be the right person. You don't sit down and say, well, wait a second, we're hiring a man, let's see what we're paying the women in that same job. Well, the law actually, I think, took out the word same job, and it says now like the same knowledge, skill, and responsibility or something like that. So what's sort of crazy making, and I won't be surprised if this one doesn't get amended or modified at some point in time, is it also took out the words, as Marla mentioned before, in the same establishment. Well, so how in the world am I supposed to know how much you're paying for the same type of work where you are, right? It doesn't make any sense, and yet presumably we're supposed to somehow be in compliance with that and pay everybody the same rate of pay. From a practical standpoint, my opinion, this is like virtually impossible to be in compliance with given the way it's worded right now. I think what I would recommend, and Marla, jump in on this if you disagree, is you just have to be really conscious that you're not paying people for the wrong reasons. You're not paying them tied to what they used to make. You're paying them based on the level of knowledge, skills, and abilities and level of responsibility for that particular position, and you have to take a look and make sure that if you're paying someone of the opposite sex differently, and I would just say if you're paying two people differently, that there is a reason that you can explain for that difference that is not tied to gender, that it is tied to something else. you know, the level of education, the number of years of experience, the tenure they've had with the company, and I would add geography to that list, even though technically it's not there. But I think, again, a reasonable person would say, well, that's obvious. I'm going to pay Kansas and New York, you know, City differently.
Okay, and great. Just to add to that, because the question asked and I didn't address it, the penalties on that are, you know, back wages and interest. So if you paid me as a woman $40,000 a year, but you paid the man's $50,000, the remedy would be I get the difference in back wages, and then I get interest on that. Now, how far back, I don't know. But also, you know, going forward, you're going to have to stop it. You can't retaliate against me or take any discrimination against me as well. I agree with Linda. This is really difficult for employers, but you should, as a takeaway, I think I mentioned this when we first started talking about it, do an analysis of what you've got to the extent you can. This is really hard for those employers who have hundreds and hundreds of employees. But if you don't, if you make a list of everybody, and if it turns out you have salesperson A and salesperson B and you're not paying on commission, salesperson is probably a bad example, admin 1 and admin 1A, and they're doing the same job, and one's a man and one's a woman, and they're getting paid differently, you got to look at why. Is there a reason? Is it education? Is it training? Is it seniority? Is it those factors that we talked about? And if there's nothing else there, we need to look at it and see if maybe we need to fix that. Okay. Very good place to be proactive and not wait for someone to complain about it.
Great. Tilly's wondering if you can
take a look at your job descriptions, Julie.
Yes.
I was just going to say, and take a look at your job descriptions, because that's the first thing that anybody's going to ask for, right? If they come in to investigate this or they file some sort of claim, is they're going to say, let's look at all your job descriptions. So you want to make sure, if you have written job descriptions and you're using those, that you review them to make sure that there's going to be differences between them.
Okay, good. Thank you. Good tips, guys. Kelly's wondering if you can explain the pay secrecy law again.
Marla?
If we could explain, I'm sorry, well, I didn't hear the question. If we could explain the what?
Pay secrecy law?
There is no secrecy. Pay secrecy is prohibited if you look at the site. So, and this is something that we're not real sure what some of that means. Under the National Labor Relations Act, it's always been prohibited from employers to require employees to keep their pay confidential. I can walk down the hall and ask anybody, hey, what are you making? What do you make? Are you happy with your job? Because that's terms and conditions of employment. It's designed to allow employees to unionize if they want. So you can't prohibit them from talking about their pay. This law goes a little bit further in that it says it allows employees to inquire about their own and others' wages. Now, current law allows them to do that with each other. What is unclear about this law, does that mean they can go into HR and say, hey, tell me what the CEO is making? I don't think so, and I think that's an area we'll get clarification on. But it's not pay secrecy, it's pay secrecy is prohibited.
Okay, good. Thank you. Van's wondering if smaller employers of 50 or less employees must report total rest and recovery periods on pay stubs.
This specifically applies to piece rate. Okay, so general employers, not necessarily. Now, I heard something this morning from somebody that said you have to also take a look if you're paying commission and bonus, and it may sort of qualify under the piece rate, and I didn't have time to look into that further. But we're specifically talking about the piece rate law. So if you're paying piece rate, you have to break out non-productive time, so people are sitting around not doing anything but still under the control of the employer, and rest and recovery periods. Okay, so normally that would be breaks. Potentially, if you're like in the agricultural and there's a heat, recovery period or something, that as well. But for most, at least of our clients, it's going to be if you're paying piece rate. So you do have to break it out. Again, I don't see any exemption for small employers. Good luck with that.
Okay. All right. Diane,
Julie, just to jump on the piece rate thing, if anybody has any questions about the piece rate and you are using piece rate, as Linda said, it is very, very technical. The law was signed into effect to address primarily agricultural workers and transportation workers. I'm not even well-versed in it. I actually have my associate is much more well-versed in it than I am. So if you do have specific questions of piece rate, please email them to either Linda or me, and we'll get them to the right person.
Okay, great. Thanks for offer. Diana's wondering if you guys have heard any plans to have the California exemption salary increased.
I have not. The only thing that's gone back and forth, I know, over the years is whether or not there should be like a flat amount, and that was more at the federal level. They were trying, I think, to get that passed. You know, if somebody's making over whatever threshold, like $100,000 a year, they're automatically exempt regardless. But I have not heard anything like that in California, nor would I expect it to pass in California. Marla?
I've been screaming for it for years, and that's why Linda probably thinks she's heard it. And nobody talks about it at all. So no, I don't. I haven't.
Marla and I talk about it.
Yeah. Anybody who will listen, Marla talks to about it.
No, I mean, and that's what's really difficult. I mean, California, that's why we do this every year in January, is because California just has such higher burdens than other states. I've got employer clients that have employees in probably every state out there if I made a list. It's so hard to just stay compliant in general, but so many of the other states just go based on federal law. California, welcome to California, it's got a whole nother level of law on top of the federal law that you have to be compliant with.
Okay. All right, good. Crystal has a question. How does providing paid sick leave time up front at the beginning of each 12-month period impact an employer's obligation of the sick leave law?
Well, we think that's the way to do it. I think anybody that's doing the accrual, the only time I recommend accrual is if you have very limited part-time people or temporary people. And the reason for that is if you're doing it on an accrual basis for the sick leave, you have to accrue it and allow it to continue to accrue up to 48 hours, but you can limit the time off to 24 hours. But I just think that's really, again, not practical, because you're going to have an employee look at a paycheck stub that says, oh, I've got 48 hours accrued. I'd like to, I'm not sick. I want to be paid for those 6 days. And you're going to say, oh, I'm sorry, but we're going to limit your time to 24 hours. So there's so many different other obligations go with the accrual that our recommendation is always that you front load it. So the requirement is that you provide 24 hours or 3 days, whichever is greater. So if you're working like a 440 work week, it would be 30 hours. We're assuming everybody's working a 5 8-hour work week. So you would front load it 24 hours. For employers that started that in July, you can keep it on a July basis. You can front load it tied to the anniversary, the hire date and anniversary date. Most of my employers, what we recommend is that every December 31st, you wipe out whatever's left over for sick. Everybody gets 24 hours again on January 1st. And that way you don't have to tie it to any dates that you can't remember. You could also do it every July 1st. Whatever's left over does not have to move forward. You don't have to pay it out upon termination, and that's why, in response to Peter's question before, I said for him, I'm recommending that he front load 24 hours of sick pay, and then specifically 9 months later start accruing PTO that will be used for whatever he wants, because if someone leaves in that first 9 months, it doesn't have to be paid out. So I don't know if that addressed your question or not. But front loading is the only way, as far as I'm concerned, to go. For some of my employers that offer more time off, like 40 hours a week, we're doing a step down. So if they start like in the first quarter of the year, we front load them 40. If they start in the second quarter, we front load them 30. And then for the second half of the year, you can't go below that 24. So we would front load 24 hours.
Okay. Marla, did you have anything you wanted to add to that?
Nope.
Okay, great. Well, unfortunately, that is all the time we have for questions. I know we have a number of them. I will send them on to both Linda and Marla, but feel free to email them if you have questions. I've got their email addresses up here right now, but they're also in the downloadable packets that you were provided in the handout section. Again, I want to thank you for attending. Linda, I thought maybe I could ask you to maybe talk about the next webinar. I know you mentioned it a little bit, a little late. So could you talk about the next webinar on February 18th?
Absolutely. So here are the dates for the next 2 webinars, actually, and then the registration link for next month. We did this, I think, 3 years ago, and the laws have changed, but also this is one of the questions we get more often than probably anything else is, how do I handle this situation? What leaves apply to me? You know, do I have to give somebody leave of absence? What happens if they exhaust it? Do I have to extend it? All those things. So in February, we're going to talk specifically about medical leave. So if an employee personally has a medical leave, you know, what are the rules around that? And then in March, we will tackle all of the rest of the leaves. And again, in California, that's about another 17. So hopefully you can join us for both of those. And go ahead and get registered, and we'll look forward to seeing you on February 18th.
Well, and again, on behalf of Linda and Marla, we thank you so much for joining us. We really do appreciate your time and look forward to providing you with more useful information in 2016. Have a safe and enjoyable day today. Thank you.